Hello, everyone, and welcome to this event tonight. Thanks for joining us on this hot and sticky evening. I hope you've got a glass of something long and cool to accompany you through the hour. I certainly have. Before we start, can I thank my colleagues James Harrison and Sarah Glenister for their work behind the scenes. They will be monitoring questions and placing links in the chat box as we progress through the hour. If you have any comments or information you want to share, then please put it in the chat box. That's if you're on the Zoom, of course. Sarah will also be sharing some thoughts and quotes on Twitter, so feel free to retweet. The event is being recorded, so can be watched again and again afterwards. The topic for tonight is human rights and employment rights. How might workplace rights look in the future? It's a big topic. In fact, it incorporates really three big questions. How might workplaces look? How might rights look, and how will the future look? We keep talking about a post-pandemic society, but no sign of it yet. So three big questions, really, and we've got three excellent speakers who will each cover a specific aspect of the future at work. And with only an hour to hear from all three speakers, I've agreed to keep my introduction short and to the point, so I'm going to move directly on to our speakers in the hope that there will be time at the end to take questions and comments from those who are watching. So, on to our first speaker. Our first speaker tonight is Dr. Philippa Collins. She will be looking at the human right to privacy and the future of work. Philippa is a lecturer at the University of Bristol. Her research focuses on labour rights and human rights implications of the use of new technologies at work. Her work's been published in a number of top labour law journals and on blog pages, and I've had the pleasure of hearing Philippa talk on a number of different platforms, but from the audience and not from the chair. So welcome, Philippa. Thank you for joining us, and thank you for kicking off this event tonight. Good week to talk about privacy. I'm sure not many employers are using the sophistication of Pegasus, but it shows what is possible when the will and determination is there. So what are workers facing, Philippa, in terms of privacy invasion, and how can they and their unions respond to the issue? Over to you.
Thank you so much, Caroline, and to everyone at the Institute for inviting me. Hopefully you can hear me okay and see my slides here. So as Caroline mentioned, I'll be talking about the human right to privacy and what that might look like in some version of the future at work. So what I'm going to cover in kind of some semblance, hopefully, of order, although please excuse me, it is too hot to be presenting, let's all be honest. The nature of the right to privacy in the UK. So I don't know who we've got in the audience, what your level of kind of expertise is on all of this, but I thought I should just cover some of the essentials. So where do we get a right to privacy in the UK legal system? Then looking at privacy and surveillance by software, which is something that I've written on previously. I'm sure some links will be shared on that. And it's something that's happened quite distinctively during the pandemic, while people have been asked to work from home. Looking at the technology that might be coming into workplaces in the future, and then thinking about both how we balance privacy concerns in that situation, but also looking at future challenges or potential challenges for privacy in the workplace. So on your right is a very nice picture of the European Convention on Human Rights. And this is where we get the closest thing that we have in this country to a right to privacy in the form of Article 8 of the Convention, which is your right to respect for your private and family life. And as Caroline mentioned, also your private correspondence as well. So thinking about Pegasus and things like that. If you were thinking, well, I'm probably not going to go to Strasbourg, to the European Court of Human Rights. It's not every day that any of us do that, apart from maybe John Hendy, if he's on the call. Well, how would I then be enforcing this right? So you would use a national right. So if we're thinking about employment relations, you might make a claim for unfair dismissal. And the Human Rights Act 1998 is the thing that means that you can raise arguments based on the European Convention in that litigation in our domestic courts. You could also, for example, rely on Article 8 directly if you found out that the government was using Pegasus against you, heaven forbid. You know, you can also rely on it directly in national courts in what's called judicial review in that setting. But you also have other really important rights in the convention that I'm sure we're all familiar with: right to life, freedom from torture, right to a fair trial, expression and association rights. Obviously, association rights bear particular importance for the trade union movement. But here I'm going to be thinking about the right to respect for your private and family life, or approximately the right to privacy. So this is actually what it looks like. And you can see that I've used the scales there because what essentially happens when a court, either domestic or international, looks at the right to privacy, they have to first check that the right itself has been engaged, that it is relevant to your case. And I have to say, it's a pretty broad brush, pretty broad range of interests. So anything that's invading on your person, your image, your data, you know, looking into your home, all of these things and plenty more are covered by your right to respect for private life. The European Court, who ultimately sets the agenda for the scope of this right, is very welcoming when it looks at the scope of the right itself. And then the second stage is where things get a little bit more tricky, because you'll be able to see that even though it's just a very long bump of words, basically what that is what means that this right is what's called a qualified right. So it's not absolute, so you have an absolute right to be free of torture, of course, but in circumstances like Article 8, it can be limited in accordance with these specific rights and interests that are listed there. And important in the employment context is obviously you're likely to have an employer on the other side of the dispute who also has rights and interests of their own. And those rights and interests can be relied upon to limit or infringe upon even your Article 8 right. So it's really important to bear in mind that maybe unlike in some other jurisdictions, this right is very heavily qualified. And that is one of the challenges that we'll have to deal with when we're thinking about this right in the future. So moving on from the law bit, but by all means ask any questions on that. I know it's not something that most of us think about every day. Thinking about software and surveillance, also probably not something, hopefully, we think about every day. And so at the top right-hand side of that screen is a couple of the most prominent companies that are selling this sort of software. And what happened during the pandemic was many of us will know that employers aren't usually that keen on working from home. And often it's because they feel that loss of control or that a loss of ability to kind of oversee directly their workforce. And they realize that these types of software can kind of come in and help them, even when their workforce is remote or working at home. These give them capacity to log and track what their employees are doing. So we saw a 71% increase in sales of these types of software over the course of the pandemic. And that high rate of sales seems to be maintaining as well. So common capabilities, I don't know how tech aware we are, but the type of things that these softwares can do, they can log your keystrokes. So every time you hit a key on your laptop, that will go into the program. They can log which websites you look at and for how long. They can track your email traffic, including reading the contents of your emails. And they can come up with kind of productivity monitoring data, which is a little bit dubious, but it basically looks at how much time you're active. So how much time are you typing on Word? How much time are you actively browsing the internet rather than sitting on Facebook or Twitter? And they can see that because one thing that they often do is take screenshots of your screen. So you might want to share what's on your screen immediately. This type of software can force a screenshot to be taken, and your employer would therefore see the communications you might be having, whether they are private or indeed related to work. So it's pretty invasive stuff, and each package is different. I have to say this isn't all automatic. And only one I've found so far can do this on a covert basis. And I think the legality of that in this country would be very questionable. So imagine, your employer installed Hubstaff, a very common piece of software, and then you got dismissed on the basis of what you'd been up to and what had been recorded by Hubstaff. So that's probably a fairly clear infringement on your right to your private life. It's monitoring your communication, and it's also kind of affecting how you're creating links with other people, which is something that is important under Article 8. So if we were then to go to an employment tribunal, say, the courts would have to really think carefully about striking a balance between my private life and my employer's desire to monitor and manage their staff. Also potentially other concerns, like, for example, if you worked at a bank, they might claim that they had an interest in keeping client details confidential. So that could give an extra kind of boost to their legitimate aim. So this is really where it's really important to remember that it is a qualified right. It's not an absolute right. So I can't kind of play the trump card of privacy. And the fact is that they're going to want to consider whether I'd been told in advance, whether I'd been given notice, how invasive was the surveillance? Were they just tracking my keys, or were they taking screenshots of personal information? Really, really different situation. And the consequences for the employee. Other things, whether there are safeguards in place to protect my privacy and things like that, will also weigh in the balance. But it's quite unpredictable. You see, there's quite a large range of factors. So it's not always easy to predict where the court is going to go. And I have to say that the domestic courts have no experience of doing this balancing act, really. It's only recently come about that things like email tracking or email monitoring have been tested under Article 8. So we've got no idea really how this would play out when you go to, for example, an employment tribunal. So this is what some people would call the nightmare dystopian slide that I whip out every now and again. So thinking about tech in the future of work, which is our kind of broad theme today, where might the employer be going next? So very well covered is things like artificial intelligence being used to monitor expressions in interviews. So say if you're having a Zoom interview, you might be very engaged, you might be very enthusiastic, or you might be quite closed, and AI can try and recognize that through scanning your face throughout your interview. And that's already being deployed. All sorts of problematic difficulties there, things like fairly rife disability discrimination, I would say, is going to come to pass around that particular issue. But that's already happening. Tracking worker concentration using similar facial recognition software. Amazon is the kind of bastion of all things technological and surveillance focused. They are very, very heavy in monitoring their own workers, and they tend to invent new things in order to do so. The biggest one being a wristband that tracks the literally where the individual is moving, so that they can be most efficient in picking up your box and getting it onto the kind of delivery van as quickly as possible. And if they're not being sufficiently efficient, they get a buzz on that wristband. And that's something that Amazon has actually patented for themselves. Fun times, guys. So continuing around, lots of other wristband options. So you've got your classic Fitbit. You share your Fitbit data with your employer. They know a lot about you then, particularly about your health data, which is a real worry. Moodbeam is a bit of a weird one. It's a form of emotional tracking. So you would tell your Moodbeam bracelet on the bottom left whether you're stressed or whether you're happy. I'm not really sure why they do that. A little bit more dystopian to the middle bottom of the slide, that badge that's sitting on his chest is the Humanize Analytics badge. And it tracks supposedly when you're having conversations, but not the topic of conversation. It definitely tracks your location. It claims to track something like 30 different types of data about the individual wearers. And the idea is that you'd wear that in the workplace when you're interacting with your colleagues, and that would somehow help your employer assess your productivity and assess kind of the office's productivity more generally. So quite strange, potentially quite invasive in terms of the amount of information your employer is getting. In the middle, you've got actually quite a positive one. This is an exoskeleton, so it basically helps your muscles and your joints withstand a lot of pressure. That's actually a military grade one, but you might have, for example, if you've got doing heavy lifting above your head, you might have a shoulder and arm brace that helps your joints withstand that kind of pressure. So health and safety is interesting, and there are definitely some positive innovations out there. Probably the weirdest one, if you look at the X-ray hand very closely, in fact, you'll see a little silver mark between the index finger and the thumb. That's a little chip So kind of like think when you put a chip in a pet, similar thing going on here. At the moment, they're only used to kind of, so I think you can put like monetary credit on your chip and use it to pay in the workplace. I don't know why that's so important. You can also use it as the equivalent of an access badge to get through doors. Quite strange. It's only being used in America, as far as I know, on a very, very voluntary basis. So nobody's being forced to use these. But there is a company where they had something like a 98% take-up rate because they just didn't want to get their wallet out. To me, absolutely bizarre, but I suppose whatever floats your boat. So that's what we're looking at in the future of work. There's lots of different things. There's new types of surveillance. There's new programs and analytics processes that these new types of data can be put through in the form of AI. And that not only looks at what you have done, but AI can also be used to predict what you will do in the future. So for example, a very famous case is Target, knowing when a woman was planning on getting pregnant on the basis of what she was buying in their store. Really strange, and it really can be really unexpected in how it makes those links and those jumps, but it can predict what you're likely to do in the future, and employers can have access to that kind of algorithm now, in fact. And then there are other things that are more questionable. I'm not sure whether employers in this country will be chipping us anytime soon, but it's not beyond the realms of possibility. So challenges for privacy in the workplace, new technologies. How do we understand them? And particularly in the legal sphere, if you're thinking about things like predictive algorithms, how are you going to, as a litigant, how are you going to engage with that? How are you going to understand that? And then how are you going to explain it to a judge? That's probably, I think, one of the biggest challenges at the moment. Transparency issues, particularly again around algorithms, a lot of them are protected by proprietary status, so they are owned by a company, and so we don't know what's in them, we don't know how they work, and again you'd need a lot of expertise to understand them, even if you did get access. A lot of the problems also come with this fact that you've got an algorithm doing a lot of the reasoning, and that means the employer might try and shift responsibility onto that algorithm and kind of away from them. So they could say, well, I'm not liable for an unfair dismissal. It was the algorithm. And this trick is already being played. So how the courts are going to deal with that, I'm hoping they're going to deal with it sensibly and say, well, you used the algorithm, so that's definitely your bad. Lack of really hard line boundaries, right? So when I said about privacy, that's a qualified right. So it's not absolute. We can't say in advance, this is right, this is wrong, this is an abuse, this is fine. It's very, very difficult to predict which way the courts are going to go. And therefore, you can imagine that employers might be testing the boundaries. They might be pushing it as far as they think they can get away with in order to get that data, which is so precious. And then we also have to think about these increasingly invasive technologies. I think it's the duty of the state to start thinking about what should be prohibited. I think we don't leave it down to employers because, as I say, I think they'll push it as far as they can. And one of the backstops, one of the most important rights we have at the moment is GDPR, or the Data Protection Act, in this country. And already we're seeing reports, obviously now we're delinked from the GDPR itself, the European Union version. Now Brexit is firmly a moment that has passed. We're already seeing the potential that some rights are going to be watered down, or the whole structure might even be dismantled in favour of a British data protection regime. I should also say the same risk hangs over the Human Rights Act, although no Conservative government actually seems to have managed to get that through yet, even though they keep threatening. I'm perfectly happy for them to stay that way, and I'm really hoping that they don't manage to get that through. So think about what rights we might need for the future. So we've seen the technology, we know that the Balancing Act is going to be really important. I'm going to wrap up on this slide, I promise. The right to disconnect. So I think a lot of us will have that experience, especially when you're working from home, of thinking, oh, I could just do 10 more minutes. I could just log on at 7:30 rather than 8:30 and just get my work done. And that also leads to a potential, so there's a massive acceleration in hours, but also an expectation that you've got your laptop, why can't you respond to an email at 8:30? you don't have children or a life, or, you know, all of this. So that the response to that is what's called the right to disconnect, and it's been enacted in France, but via the mechanism of trade union or worker representatives negotiating with specific employers. So it's not like there's an act that sets out what it means to have a right to disconnect. But we could think about what that would look like. This is something that the Union Prospect is looking at quite hard. So thinking about outside of working time, you have a right not to be asked to do any work. And if you say no, you can't be disadvantaged. Something like that could be really useful. After 6 p.m, my time is my own and I can choose to do work, but you can't demand it from me. Another thing that's going to be increasingly important, and possibly we could just about get under the GDPR, but as I say, that's at risk, is the right to access algorithms. So if you're thinking that you have been, say, discriminated against, you need to know what's actually happened, what process your data has been put through. So using trade unions perhaps to pull together some expertise to check how your data is being used, what surveillance mechanisms you've been placed under, and how algorithms are getting to the conclusion that they've arrived at. Spain seems to be the furthest ahead in this, and there's been, so digital platform workers have a statutory right, I think, to this sort of access, but there are also trade unions collectively bargaining for this exact type of right. So that's really interesting. And then thinking finally about whether some privacy rights mean prohibitions, essentially. So are there some types of tech that we're just not comfortable with in this country? So, I mean, I have to say, you're not the first audience to have a real strong response to the chip, but other forms of surveillance, so biometric surveillance, surveilling your health data, facial recognition is another one that's quite commonly considered for a prohibition, or types of processing could also be banned themselves. So you might want to ban wholly automated processing, which is currently in Article 22 of the GDPR, with some exceptions. Or you might want to place a ban on processing using discriminatory algorithms or inaccurate data, all those sorts of things. So there's lots of things that we could think about, but I think we need a government that are forward thinking and are proactive. And I'd maybe raise some questions on that score. I can see Caroline laughing. So at that, I'm going to leave it. I don't think I've got any more slides for you. So I'll stop sharing my screen. And it's been a real pleasure to talk to you all. Thanks.
Thanks very much for that, Philippa. It is an amazing set of information that you give. It is amazing, isn't it? But it's also scary. And it's a shame that that level of intelligence and technology can't be used for the benefit of people. You know, I laughed when you mentioned getting something off the government, but here we have a government who can't introduce an efficient track and trace system during a pandemic. And yet everything is there to be able to track and trace workers by their keystroke, by their movement, by their emails. I mean, you know, strange. It would be interesting to circulate your slides. I don't know if that is possible, but that would be great. You mentioned judicial review and that being a way of preventing abuse of overuse. But of course, today we saw the introduction of new proposals to cut back on judicial review, which again is closing down an avenue for people to be able to control the control that is used over them. So great stuff. Thanks very much for that, Philippa. I'll move swiftly on to our next speaker, and our next speaker is Professor Keith Ewing. Keith is going to talk about trade and cooperation agreement, in other words, the Brexit deal and the future of labour law. First, let me say a few words on Keith. He is Professor of Public Law at King's College London, but more importantly, he is President of the Institute of Employment Rights. He's the author of many IER publications and the coordinator of numerous IER projects. Back in his day job, Keith is widely recognised around the world as a leading scholar in labour law, trade union freedom and constitutional reform, always aiming to improve the political process and the status of social and economic rights. I'll shut up now, Keith. You're looking as if you're embarrassed. So, Keith, I know you are somewhat sceptical about the concept of human rights and how it's used and abused in many neoliberal states, but does the recent Trade and Cooperation Agreement provide an opportunity for us to grasp the concept of human rights and run with it to our advantage? Maybe look at that, or just say whatever it was you were planning on saying anyway. Over to you, Keith.
Okay, thank you very much, and thanks everybody for coming tonight. I thought I'd speak about the Trade and Cooperation Agreement, which is as Cad said, is the Brexit Agreement, which is a beast of a measure. I mean, it's a very, very long document of several hundreds articles. But it's been largely invisible since the agreement was negotiated. And I think, it's fair to say that we would not expect to find in a trade and cooperation agreement or a free trade agreement any provisions relating to human rights or any provisions relating to the human rights of workers. But in fact, there are provisions there which I think we need to be better aware of and actually start mobilizing to try to make better use of these provisions. So my mission tonight is really just to try to set out some of the measures in question and just to alert you to what is actually there and perhaps to suggest what we might be able to do. But just before I go on, let me just say that by way of just to follow on from Philippa, the preamble to this document, and it's more than a free trade agreement, it's about a new economic and political relationship between the UK and the EU. And it begins in the preamble with a first line of the document is a commitment to democratic principles, the rule of law, and to human rights. And then there are further provisions in the text. There's about 200 pages or articles of the text which would cease automatically to apply if the United Kingdom was to cease to be a party to the European Convention on Human Rights. So I think we're locked into the convention. Now, as Philippa suggested, we're not necessarily locked into the Human Rights Act in its present form, and I would expect the Human Rights Act to be amended and diluted in a number of different ways over the years to come. But that's one point. But the main focus, I think, for me is what it has to say about labor rights as human rights, so the human rights of workers. And that's what I want to focus on here. And if you look at the treaty, in a sense, there's no reason why anybody would want to look at it. But there are two different chapters in the treaty which deal directly with the human rights of workers. And the first of these is Article 386. And what 386 does basically is it lists a number of areas of employment law, including fundamental rights of work, and makes it clear that these areas of law are not to be diluted. There's not to be any further regression from the standards in place at the present time when the regression or changes are taking place in order for the United Kingdom to gain some trade or investment advantage over the European Union. So basically, you can't dilute labour standards, including fundamental labour rights, which includes the 4 core ILO principles, which include freedom of association. You cannot dilute these in order to secure some trading benefit. And if you do, there are certain remedies and sanctions that might be visited upon you as a result. Now, the other provision, however, is much different. I think it's much more interesting, and that is Article 399. And so, in a sense, if there's nothing else that you take away from my 15 minutes, take away these 3 numbers, 399. And Article 399 of the treaty, I think, is a freestanding commitment to the protection of a number of labour rights, which I find, frankly, astonishing that Johnson has signed up to, and certainly that Johnson and the Conservative Party in its present form, that they would have signed up to what is actually set out there. And in terms of 399, I think they're just worth highlighting three particular provisions. It's quite a long article, but the first of these provisions that I wanted to highlight is 399.2, and this commits both parties to the treaty, that's to say the EU and the UK, to respect, to promote, and effectively to implement the internationally recognized core labor standards as defined in ILO conventions, and also to take steps effectively to recognize the right to collective bargaining. So this is an important commitment, I think, which is strongly expressed to respect and promote, a commitment to respect and to promote and effectively to implement these core labor standards. And then secondly, if you go to 399.5, and what you see is that each party, that's say UK and the EU, then commits to implement, all the ILO conventions that the United Kingdom and the different member states respectively have ratified. And that is, again, I mean, that's a very strong obligation. It's an obligation, it's a commitment to a wide range of international workers' rights treaties. And in the case of the United Kingdom, I think we have ratified somewhere between 60 and 80 ILO conventions, which the commitment to comply with which has now been reinforced by this treaty provision. And then the third point I wanted to highlight is Article 399.5. So the second point which appears in 399.5, and that is also a commitment to implement the different provisions of the European Social Charter that as members of the Council of Europe, which the United Kingdom is, we have accepted. And in the case of the United Kingdom, I think we have accepted about 45 of the 60 of the 72 numbered paragraphs of the Social Charter. And that again, it's in a sense, there's quite a, if you look at this, I'll say something about this in a minute. If you look at the Social Charter of 1961, there's a wide range of labor rights which are actually protected in the Social Charter, which recognizes workers' rights or labor rights as human rights. So these are three provisions. One, a commitment to the fundamental rights at work, a commitment to implement all the ILO conventions that we have ratified, and a commitment to effectively implement all the provisions of the European Social Charter that we have accepted. And just by the way, in giving effect to these commitments or obligations, what the treaty also makes clear is that in determining what the various provisions of the treaties mean, we've got to take into account the case law as it has been developed by the supervisory bodies of the International Labour Organization, that is to say the Committee of Experts, or the Council of Europe, that is to say the Social Rights Committee. And that's, I think, probably the first time that has ever happened in a treaty of this kind. So that is the obligation, it says. That is a commitment that we have made, the British government under Johnson made. This is what the British Parliament has accepted when it accepted the treaty earlier this year. And the question then is, what are the implications of this? And the implications, I think, is, well, if you go, the implications, I think, are quite profound. I mean, if these obligations and commitments are to be taken seriously, and in the case of the fundamental rights at work of the ILO fundamental conventions, the 8 fundamental conventions, 4 principles, fundamental principles of rights at work, I mean, what this would mean is that we will need to revise our law insofar as that we have legislation which interferes with trade union internal governance and autonomy. We would have to scrap the 50% support or ballot approval requirement for collective bargaining recognition. We would have to remove many of the restrictions on industrial action, which have been developed since 1980. We would have to remove the 40% threshold, ballot threshold for industrial action in the case of transport and education workers that was introduced in 2016. And I think more controversially is we would have to remove the legal restrictions on the right of trade unions to take solidarity action. All of these restrictions have been found by the ILO Committee of Experts to be incompatible with international labour conventions, and in particular Conventions 87 and 98. Secondly, if we go to the more generic commitment to commit to all ILO conventions that we've ratified, well, this takes us again, in a sense, what we need to do here, I think, is we need to make an inventory of all the conventions that we've ratified and all the violations which have been held over the years by the supervisory bodies to which we have not ratified. And I'll give you an example of one which has been a long-standing violation, and this relates to what is called Convention 17, which deals with, it's referred to, the title, a very old convention, the title is Workmen's Compensation Accidents Convention of 1925. Now, under that convention, the supervisory bodies have said that where a worker gets injured at work, it is not lawful under the terms of this convention to require that worker to pay for any drugs or medicine which he or she, basically prescription charges, which he or she incurs as a result of the industrial accident or injury. And that's just an example of the type of thing that the Committee of Experts has been banging on for years and years about, requiring the British government to change, but which British governments over the year have refused to change. Well, now we have an additional obligation under the Free Trade Agreement to look at this and various other provisions, such as the provisions, the violations of the Forced Labour Convention, to the extent that we allow in this country prisoners to work for private companies without being paid the national minimum wage. So all of this has to go. All of this has to be revised to comply with the Free Trade Agreement. And then thirdly, just very briefly, the Social Charter of 1961. Well, in a sense, last time this was looked at by the Social Rights Committee, the committee found it looked at 13 obligations that the United Kingdom had signed up to, and found that we were in compliance with only 3 of these and in violation of 10. And the violations are quite far-reaching and wide-ranging. They include, for example, national minimum wages, which are not high enough. They include things like the absence of any obligation to make bonus payments for overtime working or overtime rates, as we used to know them as, and various other provisions. Holiday pay arrangements are not satisfactory, notice before termination of the contract arrangements are not satisfactory in this country. So there's a whole suite of issues there as well that would need to be addressed. So basically, I think, I'll just wrap up on this, but I think the point is that under 399 of this agreement, we need to know more, it needs to be more widely known. There are obligations to comply with fundamental labour rights. There are obligations to comply with all ILO conventions that we have voluntarily ratified. And there are obligations to comply with the European Social Charter's provisions, which we have voluntarily accepted. And the question then is, how do we go about enforcing this? And I think what I've spent my sense is that there are procedures in the treaty which will allow for enforcement. There are provisions in domestic legislation, Section 29 of the European Union Future Relationship Act, as it's called, 2020, which gives effect to the treaty, which allows in Section 29 some provisions of the treaty to be directly enforced in the domestic courts. But we've really got to up our game on this. And it's time, I think, for the Labour Party and for the TUC to get engaged with this treaty and actually to try to make it work. Thank you very much.
Too busy writing all that down then. Keith forgot to press me.
All right, I'll be writing it down.
Thanks very much for that. That was excellent as ever. So we've gone from scary news on what might happen to positive possibilities on what could happen. We just need to get this information out there and kickstart, as you say, the Labour Party and the TUC into doing something about it. And we have to do that before. I heard something today that they're thinking of amending this treaty to deal with the problems that they're having in Ireland. So
that's a different treaty. That's a different one.
Oh, is it?
Yeah.
Ah, right, okay. Well,
that's the withdrawal agreement.
Right, okay.
Different from the trade and cooperation agreement. So,
right, okay.
But the two are often conflated. So,
well, often confused. That's me confused.
Yeah. Well, everybody is. That's a problem.
Well, we will try and get that information out as wide as we can. That was excellent, Keith. Thanks very much for that. I will move on to our next and final speaker, who is Josie Irwin. And Josie is going to talk to us about women equality and working from home, bargaining for the best homework arrangements. Let me just say, Josie is Unison's National Women's Officer, responsible for ensuring women's concerns are incorporated into Unison's bargaining agenda and into their campaign and priorities. Before that role, Josie was negotiator for the Royal College of Nursing. She was National Staff Side Secretary for the NHS Staff Council for numerous years. She's also worked in the NHS and in local government and understands her way around local government as a councillor in Haringey, where she rose to the rank of deputy leader. Josie is also contributing to a forthcoming IAR publication, thank you very much, on the gender pay gap. Josie, it's clear things are going to be different post-Freedom Day and again post-furlough scheme later in the year. Tell us how Unison is bargaining for people like me who want to work from home and about some of the issues you're hearing about from your members. Over to you, Josie.
Thanks very much, Carolyn, and thanks very much for inviting me to this evening's webinar. If I had been talking about the future workplace and equalities 18 months ago, I would certainly have mentioned working from home. Home working was on the increase, driven by workers seeking a better work-life balance, developments in IT, and employers looking to reduce overheads. But it certainly would not have been my focus. COVID has changed the world of work and it's normalised home working. Many employers are now considering shifting to a much more extensive working from home on a regular basis. Some employers are exploring the possibility of keeping remote working as a permanent full-time option for staff, and many other employers are also considering the benefits of hybrid working, where workers combine working from home with days in the workplace. And as the restrictions ease, Unison is working out what this will mean for both those who can work at home and those who can't. Unison's 1.3 million members work in the NHS, in schools, colleges and universities. They work for local councils, in social care and for private contractors providing public services. They also work for energy companies and water authorities in call centres. An overwhelming majority are women. Most of them continued working during the pandemic, around 45% working from their usual workplace and 40% from home. For many women, working from home during lockdown has meant flexibility and a better work-life balance. However, for others, it has been exhausting, stressful, isolating and miserable. And for some, it has been a nightmare. We must be very careful not to assume that working from home is great for everyone. Choice about what flexibility looks like is key. And for Unison, it's crucial that our reps and branches actively engage in the arguments for and against home working and ensure that our members have a real choice in the matter and are not forced to accept new ways of working without consultation. It's also important to bear in mind that it is typically university educated people in management, professionals or business services who can work at home. Throughout the COVID crisis, workers in manufacturing, supermarkets, healthcare, our members and other frontline jobs have continued going to their regular workplace, as these are jobs that cannot be done at home. Some workers have lost their jobs and many more are likely to do so as the furlough arrangements taper out. We must not forget these workers. Commentary about the shift to home working tends to be dominated by the same university educated management and professional class who benefit most from it. Trade unions should be mindful of this in their own analysis and in developing a bargaining response. Unison's approach to bargaining on home working is built on our members' experiences. So one of the biggest benefits of working from home, cited by workers and employers alike, is a better work-life balance, being able to deal with domestic and work demands more flexibly within the day, not having to waste time travelling to and from work. One working mother responding to Unison's 2020 Equalities Survey said, "Working from home has been fantastic. If I could do that every so often, it would be a big help. I spend almost 4 hours travelling to and from work on buses. So before lockdown, my days were 12 hours long and I was too tired to have any kind of life or energy for my family." A further benefit is improved health and well-being. So another member responding to our Equalities Survey said, "It's much less stressful and a better working environment from home. I get so much more done. I don't have to use my car and deal with traffic congestion, so it's helping the environment. I also don't have to work in an open plan office with no opening windows, no temperature control. We sit with our coats on in the winter and use dirty desks, kitchens and toilets." Managers also reported a positive impact on sickness absence rates of working from home. Unison has found that working from home means disabled workers can have more control over the pattern of their working day, from a later start and finish time to the ability to timetable in more breaks. 54% of respondents to a Unison survey of disabled workers said that they felt they would benefit from being able to work from home after the COVID-19 pandemic is over. Well, we'll wait to see that. A more flexible way of working seems to have helped workers feel they're being trusted by their managers to simply get on with their job. And this level of trust can also provide a positive outcome for their employer. So Unison's 2020 Equality Survey also found that many members felt more productive working from home. Other surveys and reports have also highlighted the positive impact of working from home on productivity. The Institute for Employment Studies set out the results of a major research project in January. 9 in 10 employees asked felt that they'd got at least as much, if not more, work done at home as in the office. However, for some workers, home working is really not a good experience at all. Unison Scotland recently surveyed local government workers and uncovered feelings of isolation, a negative impact on work-life balance, challenges with technology, and lack of support from managers. We also can see that home working is damaging the progression of women workers, and we can see gender equality going backwards in the workplace. 1 in 6 women, mainly those on the lowest pay, have had to reduce their hours at work as a direct result of school and childcare closures. Some women have been forced out of work altogether. Only 1 in 10 low-paid jobs can be done from home. You can't clean or cater from home. And women who can least afford it are paying the biggest price in terms of the emotional, physical and financial effects of balancing work with their caring responsibilities. Most people's homes are simply not designed for their job. Nearly half of Unison's members who responded to the survey in 2020 said that they lacked the appropriate equipment to fulfill their work duties from home. And the same Institute of Employment Studies research that highlighted a positive impact of working from home on productivity found that parents, carers and managers put in more hours, struggled with collapsed homework boundaries and felt under pressure. Many of the participants involved in the research reported experiencing worse symptoms of musculoskeletal pain, high levels of fatigue, poor sleep and a higher level of eye strain. Over a quarter of the respondents to Unison's 2020 Equality Survey felt working from home brought risks to their health, safety and well-being. One member living with an abusive partner said, "Before lockdown, I was just about coping as long as I was going into the office, but being kept at home and my children spending even more time with their abuser has almost broken me." We are yet to see the full impact of blurred boundaries between work and home and balancing work and caring responsibilities on mental health. This comment from a member in response to the 2020 survey is typical. "I have felt isolated, and this has increased my stress and anxiety at a time when I am already struggling with this and trying to return from sickness. I feel like I am not winning or successful in any aspect of my life. I have chosen to prioritize my children, but this has had a further detrimental effect on my work record, my confidence, and my self-esteem. I feel unsure whether I can mentally and emotionally deal with a return to work, and this in part also has a knock-on effect on my physical health." As Philippa mentioned, French workers have benefited from a right to disconnect since 2017, when the law was passed to ensure that workers had a right to stop taking work calls or respond to emails outside of their normal working hours. And she also mentioned the change, a similar law in Spain, giving employees the right to privacy in 2019 when using digital devices. And the Republic of Ireland has also recently introduced a right to disconnect. There's no doubt that the abrupt switch to home working necessitated by lockdown has improved IT and digital skills exponentially. However, as Philippa has highlighted really excellently, monitoring and surveillance has also increased. This is part of a worrying trend. Before COVID, we were already seeing increasing numbers of checks on workers through monitoring emails, phone calls and computer use, or using cameras and other technology to keep an eye on their activities. A TUC report in 2018 found that over half of workers think it's likely that they're being monitored at work. Unison supports the test and trace approach as part of the wider aim to limit the spread of coronavirus, help get people back to work and get the economy back on track. However, we also think access and implementing testing must be transparent, fair and equal for all workers, and any personal data collected by employers or the government as part of that process, including through an app, must be responsible and proportionate and meet our data privacy rights. So, given the pros and cons of working from home, the reality that it has become normalised, and recognising that one size does not fit all, what should Unison's bargaining response be? Along with the TUC, Unison is calling for day one rights to flexible working arrangements and enhanced parental and carers leave. And we were doing so before the pandemic. However, what might suit some won't suit others, and there has to be choice. The starting point for us is that there should be a discussion and consultation with staff and involving the trade union about future working arrangements post-COVID. Managers need to be flexible in their approach and ensure all employees are engaged and supported. Even though some jobs do not allow employees to work from home, these workers still need to have equal access to flexible working. Trade union reps may also need to be mindful of the knock-on effect of increasing the home working option for office-based workers. For example, there could be an impact on the cleaners or caterers working for the same employer whose services may be reduced as a result. Increasingly, hybrid working has been presented as the more popular option for both employers and staff in working arrangements, a mix of working from home and some days in the office. We see this as a possible starting point for negotiations with any employers keen to introduce home working. However, Unison is clear that disabled workers should always have the option to work from home if they want to, as long as reasonable adjustments necessary for the home situation are made. There may, of course, be valid reasons for an employer to be reluctant to allow home working as an option for all staff. If this is the case, the employer should provide clarity about expectations about physical presence in the workplace and treat all staff fairly. Similarly, if there is monitoring, screening, or recording of phone, email, or internet use, Philippa alluded to this, there should be clarity for all staff that it is taking place. In summary, Unison's bargaining response is: 1, that all staff should be allowed to work flexibly, including working from home. 2, one size does not fit all. 3, there should be choice. And 4, there should be consultation and discussion, recognising the pros and the cons of home working and the implications for fairness and equality. And a plug now for Unison's bargaining guide to working at home and a model policy, which we've just published, and that will appear in the chat. Thanks very much.
Thank you very much for that, Josie. Very interesting, and clearly one size doesn't fit all. So some good pointers there on what trade unions might look to do when negotiating for their members. And one of the benefits of coming on the platform is you get an opportunity to plug. So you plug away. It's up there and it will be circulated to those who haven't joined us tonight as well. Now, we do have some time left for some questions to our panel. So let me ask a few. of each, and then we can just, you know, sum up from this. So Philippa, one for you. You outlined the possibilities and problems of working from home in terms of individual rights and privacy. What about collective rights and the right to organise? Have you got any tips or warnings on that? One for Keith, which came from Peter Jackson. How are the ILO conventions enforced? Is one for you. I haven't got any for you yet, Josie, but I think that's just because you've only just finished, so maybe one of those will come up for you in a moment. Philippa, do you want to answer yours?
Yeah, so I think definitely not a warning, but an opportunity for unions being ahead of the curve, being tech savvy, approaching employers that they think might be using, well, surveillance, if it's physical, is very obvious, but if they suspect that, for example, even Microsoft Office has a form of surveillance built into it. It's a productivity monitoring thing. So if it gets called like My Analytics or My Productivity or something, that can be collated by your employer. So if you're ahead of the curve, if you consult with kind of technicians, experts, you can then approach and seek to bargain, because that's by far going to be the most effective way, because then you're dealing with the specific balance in that specific organization or sector maybe, where you draw the line for those workers and on behalf of those workers on what can and can't be used. But things like recruitment by algorithm is very common. So screening, so say you've got 10 jobs and you've got 250 applicants, no HR manager is reading them anymore. They're being put through an algorithmic screening process, which can and has led to discrimination against particularly women, ethnic minorities, and people with slightly different life experience. So asking to see those algorithms, knowing exactly what's going on, I think that's really important. And there then will hopefully be an opportunity to collectively bargain. Employers often aren't keen to open up about this sort of stuff, so it might be a bit of a battle to even get them to admit that it's being used. A warning, well, there is some scary tech that can be deployed. Obviously, we all know that in the States, there's a whole sector of corporate activity which is anti-union strategy and consultation. So that can be, so there's an interesting case that's also related to Amazon, where they're using kind of data on the demographics of different warehouses of Whole Foods, which is owned by Amazon. And they plug in all these different demographics. So things like the deprivation in the local area, the mix of different nationalities and ethnicities in the store, etc., etc. They plug that in, and it kind of draws attention to what might be considered hotspots, where it's more likely that unionization or organization might start. So if that was translated into this country, that's really difficult to tackle, because you don't really have protection as a union until you're officially trying to be recognised, and then unfair practices kick in and all of this. But this is going to stop you before you've even kind of nearly got off the ground. You know, it's so early in your kind of organising career, or, you know, your organising life, that that's really difficult to tackle. I don't know, I haven't heard rumours, for example, that it's happening here, but that sort of thing isn't impossible. But also, I think if you think my Facebook is being monitored, and I'm, you know, lots of organisation does happen through Facebook and Twitter. Oh, I can't follow my union on Twitter because that then my employer will see that I follow them, or, you know, all of this sort of stuff. Or if employers are scanning Facebook, like photos of Facebook for where events have been organised, they can just see your faces. You know, all of this sort of, this kind of data leakage will, I think, start to have implications for unions. There's already dismissal cases about what's been said in WhatsApps between union leaders. So I scan for kind of all of that sort of social media type stuff. So closed Facebook groups that employers have had access to.
We need to be careful what information we give away, that's for sure. That's the
And you need to
line
be
in one of
careful.
our publications by
Yeah.
one of our EC members. So very good. You've also very cleverly answered another question, which was our job applications, when you talked about recruitment strategies and how employers are using algorithms to recruit. Now, moving on to Keith. Thanks very much, Philippa. Keith, and the ILO enforcement.
Chat, I think. Can you hear me okay?
Yeah.
Yeah. Okay, so, well, I think the direct answer would be for 100 years of the ILO's history, enforcement has been done poorly and badly. But what I would say is that the TCA actually potentially takes it to a new level. And I think the way I see the TCA is it's like a parasite, which is just basically living off the host, and the host is the substantive law of the ILO. And the TCA provides the means by which that law can now be better enforced. And I think there are three possible ways by which that can be done. Basically enforcing the ILO conventions through the TCA mechanism. One is by the political opportunities it provides, particularly in the European Parliament, if our own parliamentarians are not up to the task, and the political pressure that can then lead to pressure on the Commission with a view to bringing enforcement proceedings. Secondly, there is an enforcement process in the TCA which requires us to comply with these obligations that I discussed or referred to. And at the end stage of that process in 399 cases is binding arbitration by a panel of experts, which we've seen that happen recently in the free trade agreement between the EU and Korea in relation to freedom of association issues, which basically were based upon ILO conventions. And then the third means of enforcement, I think, is through domestic courts. I mean, I think there are opportunities by virtue of Section 29 of the 2020 Act, which will allow some of this stuff because what Section 29 says is that domestic law, that is to say, domestic legislation has to be modified, which means that expressly says it may have to be amended or repealed by the courts to give effect to these obligations. And we've also seen that in the same process at work, the recent case, ILO conventions being used under the Human Rights Act to rewrite domestic British law. So, for adventurous, open-minded lawyers, who can think out of the box, I mean, there's a lot of stuff there that could keep them occupied for the next 50 years.
Wonderful. Thanks very much for that, Keith. Again, over to the TUC and the Labour Party to take up some of those issues.
Exactly.
Right, listen, it's now 2 minutes past 8. I did promise that we were going to be finishing at 8 o'clock, so I think I should end it there. Thank you so much to all of our speakers. It's been very interesting, very illuminating. Thank you to those who turned out on this glorious evening. There's still time to enjoy a bit of sun before it sets, and our final slide tonight will show you how to sign up for newsletters, what our next event is, and other important bits of information like that. So thanks again to everybody. Hope to see you at our next event, which is Hugh Bain in conversation with John Hendy and Keith Ewan, and thanks for all turning up. Well done all.